We just had a brilliant address from the Chief Guest, Honorable Justice Muhammad Mushtaq. After a long time, I have heard a judge, sitting judge, speaking, you see, actually from his heart. So I think the decision of the organizers to invite Justice Muhammad Mushtaq as the chief guest was very, very apt and very topical. Professor Dr. N.R. Madhav Menon, Dr. Saroja Bhaskar, Mr. C. Unikrishnan, Mr. Johnson Gomes, Mr. Syriac Thomas, Mr. Shine Vijayan, Mr. Sachin Menon, Ms. Shanti Mayadevi, Mr. S. Biju, and my very worthy team of the Chartered Institute of Arbitrators India, my fellow directors on the board of CIAB, Mr. Ratan Singh, Mr. Samir Shah, Mr. Inba Vijayan, and one of the most brilliant figures in the field of arbitration in India, Mr. Tejas Karia. Friends, fellow delegates, members of the profession, worthy teachers of law, my greetings to you as the President of the Bar Association of India and as the President of the Society of Indian Law Firms, and of course as Chairman of the Chartered Institute of Arbitrators, the India branch. I would not have been here except for talk on the sidelines of a very important event which happened in New Delhi, that is rather Noida, the Lloyd's Law College, where Professor Menon and I were sitting on the dais and we were having some discussion. So Professor Madhav Menon suggested that I should visit Kochi for this very important and significant event. He told me very clearly that it is like a small beginning, but with a great potential. And this is like a movement which would need support of we people who operate from Delhi. But we have the backing of the big organizations like the Bar Association, the Society of the Law Firms. So he suggested, you see, that if it is possible for me to spare a day to come to Kochi to participate in this event, I readily accepted, because whatever comes from Professor Madhav Menon, one can never refuse it, you see, because we know that whenever he's suggesting something or he's involved with something, it definitely has a bearing on the social well-being of this country, you see. Whether it is the case of legal education, whether it is the case of judicial reforms, whether it is the case of promoting moot court competitions in India, whether it is promoting good law schools all over India. And he's been in the forefront of various committees and commissions which have been set up by the government and by other voluntary organizations. So when this suggestion came from him, I said, yes, sir, I'll be there. And because I have great regard for law teachers of this country, you see. And I was indeed privileged to meet Dr. Saroja Bhaskar last evening also. We had the privilege of a meeting with her, and today also. My problem is that why law teachers have not been given their proper recognition. Way back, you see, in 1994, when as the General Secretary of the Bar Association of India, but as the General Secretary, Secretary General of the International Bar Association, we recognized Dr. Madhav Menon as a living legend of law. At 1994, and at that time, the President of the Bar Association of India, Mr. Fali Nariman, said openly, and these were virtually his words, that why cannot we have such eminent law teachers as judges of the Supreme Court of India? That has not been, the worth of the law teachers has not been recognized in this country. There have been lawyers who have been straight away elevated to the Supreme Court, and of course they are elevated to the High Courts as a matter of routine. But I have not seen this recognition coming to the law teachers of this country. I would like to extend that principle even, say, in the field of arbitrations. Why can't law teachers be the arbitrators or presiding members of an arbitral tribunal? They are the people who are familiar with law, but they are not involved, you see, in the money-making machinery which arbitration has become today. They will bring sobriety. I think they will bring values in the field of arbitration if they are actively involved. Therefore, my appeal to various organizations who are engaged in the field of arbitration, promoting arbitration, is that you involve the law teachers in a big way so far as arbitration is concerned. What is more important is that Chartered Institute of Arbitrators, and we will embark upon this, we'll adopt this as a principle in Chartered Institute of Arbitrators to have more involvement of the law teachers. As a matter of fact, our very eminent members of the board of directors who are present here, they do engage in a big way. They're already engaged in a big way with the law teachers, with the law schools, and with the senior law students all over India by conducting training courses, and at no personal gain to them. Rather, they must be spending out of their own pockets, you see, to come to Kochi, or to go to Chennai, or to go to Ahmedabad, Bombay, Delhi, Nepal. That is what, you see, our worthy members have been doing. And that we have to take as a mission to continue to involve the teaching profession in law particularly. And training is so important. Training is the basis of Chartered Institute. It is the charter of, you see, the Chartered Institute of Arbitrators. We have been set up by a royal charter of the United Kingdom to promote training of arbitrators and mediators. So we are not in competition. I must make it very clear. We are not in competition with any other institute which promotes arbitration. Like you have the ICC, ICC based in Paris, you have the Singapore International Arbitration Center based in Singapore, the LCIA in London, and then Dubai and Kuala Lumpur and all that. In India also you have some of these institutions, but we are not in competition with them. What we provide them is the most essential part of it, that is trained arbitrators, trained mediators. That is something which no other organization does it. And the accreditation which is given to those who are involved here is recognized all over the world. If someone is a member of CIAB, he is recognized. If someone is an associate of CIAB, they are recognized. And of course, those who are fellows of CIAB, they are recognized all over the world as trained arbitrators. So that is the benefit, and when Professor Menon spoke to me, I say we would definitely extend full support to this initiative, which has originated in Kerala. And Honorable Chief Guest was saying that it would help in promoting arbitration in Kerala. I'm not talking of that. I said this will help in promoting arbitration all over the country. It is not just confined to Kerala. What you are trying to achieve today here, I'm sure, will have its reverberations, and you see the information, the dissemination all over the country. And this initiative needs to be encouraged. But how do we involve, you see, the cross-section of people? As the Honorable Chief Guest said, that we have developed a 5-star culture of arbitration, where arbitrations are conducted by retired judges of the Supreme Court, of the High Court. Lawyers, you see, they go there. Sometimes one day of arbitration is split up into 2 sessions so that both the arbitrators and the lawyers can make a lot of money. 1 session pre-lunch, 1 session post-lunch. So that is a 2 set of fees for the arbitrators sitting in a 5-star environment. Arbitration is virtually monopolized in India by retired judges and members of the legal profession. I want this to change, and I want that this should happen quick and fast. We have to involve other experts. We have chartered accountants, we have company secretaries, we have engineers, we have architects, we have retired bureaucrats, all very seasoned people. And of course, now I'm adding on to that the law teachers. They should all be involved in arbitration after getting duly trained in the field of arbitration. Why can't an engineer become the presiding officer of an arbitral tribunal? Why can't an architect become? Why can't a chartered accountant become? Why this position should be monopolized by judges and by lawyers? Because in arbitration, as against, you see, litigation, what is required is going into facts, into facts, and going into the technical aspects of the disputes. Because these are not ordinary disputes. They are construction contracts. You have to go into various kind of complexities. The legal points can be taken care of, but more importantly, you have to go into the various technical aspects for which the technical people are the experts who can render effective arbitration help. Having said that, why arbitration has not taken off in India? And I can share that with you. I say that arbitration has virtually failed in India. It has failed because, as I said, one reason is monopolized by judges and lawyers. And other reason is, of course, lack of institutional arbitration. That is where the relevance of such workshops, such seminars, such conferences, such initiative becomes very relevant. Lack of institutional arbitration. If arbitration has to succeed at all in this country, and I have grave doubts about it, then it must broad base, you see, itself. Other disciplines have to be involved. And why do we call it ADR? The very fact that you have given it a name as alternate dispute resolution, it reduces, it minimizes the significance because it is supposed to be an alternative to something. I think we have to shed this. One is dispute resolution, dispute adjudication, which is done by the courts. That is adjudication. Dispute adjudication done by the courts. But so far arbitration and mediation is concerned, it is dispute resolution. It is not alternative dispute resolution. It is an independent branch and it has to be developed as such, not as an alternative to litigation. I think we should stop comparing litigation with arbitration. Arbitration has to be developed as the only mechanism for dispute resolution along with mediation. The dispute adjudication is in the domain of the courts and they will perform their duties. Where only 4 days ago, I was in Rashtrapati Bhavan where the first copy of a publication by Justice Dalveer Bhandari, Judge of the International Court of Justice, was presented by the Prime Minister to the President of India on judicial reform. The book is on judicial reforms. And in the distinguished presence of the Chief Justice of India. So the Chief Justice of India there spoke very bluntly about it. He said, I don't know about arbitration. People are saying that arbitration should take off, we should promote. He said, I favor mediation in a big way. And he told the government, the Prime Minister was sitting there, all the other judges, Arun Jaitley was sitting there, Ravi Shankar Prasad, they were all sitting there. He told them, why the government cannot evolve a mechanism to resolve its own disputes wherever government is a party. He said, government is the major litigant in the country. And he said, even if 10 to 15% cases are, through some internal mechanism, are taken off the roster of the courts, he said that itself would be a big way in reducing the arrears. So what was in the mind of his lordship was that mediation or some sort of a settlement mechanism should be put in place so that dispute resolution can really become effective. And he said what we lack is also trained mediators. Of course, we lack trained arbitrators. With great respect to the judges, every judge thinks that having served the High Court or the Supreme Court, they are experts in everything. But our experience is they are not experts. But the problem is they don't rely on experts also. They want to decide everything themselves based on their judicial knowledge, which is devoid of any technical expertise which they do not possess. There is a committee set up by the government, headed by Justice B.N. Shri Krishna. Frankly speaking, I don't have faith in these committees and all that, you see. We have had so many committees. We have been experimenting with the arbitration law. At the drop of the hat, we want to bring in amendments and this and that. Mr. Tejas Karya, you see, I had the benefit and privilege of being associated with him in the Law Commission, where we made some recommendations to the Law Commission, and we don't know whether the Law Commission had forwarded those to the government. But eventually nothing comes out of that. Arbitration, if at all it has to develop, it will not help, it will not develop because of these committees and all that. There has to be a change in the mindset of the people. You have to create that awareness about the efficacy of arbitration as a dispute resolution mechanism. That is, these committees will come, they will give their recommendations. We don't know how they will be implemented, whether they will be diluted. But then again, it all evolves. That is, it is an evolutionary process. Very well, we wish good luck to the committee, and we hope that some good recommendations will come out of these. But I must, in my closing, express a great hope that though this is a small gathering but it is a gathering of very, very committed people. And it is the quality which matters, not the numbers. And I'm sure that the message which will go out of this workshop through all the dignitaries who are sitting here and in the working sessions which will follow here, the technical session, will really bring about a momentum which will be not only felt in Kerala, but it will be felt all over the country. Thank you very much.